Okay, good morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court. Today, I'm going to tell you whether I found probable cause. I've read all these probable cause affidavits, and I will let you know if I found probable cause, and then we will talk about release conditions. Today's not your trial. And so my advice to you today is to not to talk about your case on the record, because everything in this courtroom is being recorded and can be used against you at another time. Now, I've been saying this now every morning, because every morning I say this, and every time inevitably somebody comes up and says, Judge, I'm not talking about my case, but, and what comes after but is you talking about your case. So there are attorneys in the courtroom. In the courtroom, we have an attorney from the Public Defender's Office, Mr. Brian Reedy. Over at the main jail, we also have an attorney from the Public Defender's Office. Those of you who are represented by the Public Defender's Office, you want to talk to your attorney before you say anything on the record. Today's not, also, if you have a private attorney, the private attorneys usually come into the courtroom and they will speak on your behalf. I have a representative, an attorney from the state attorney's office. That person is here, and also Mr. Eric Linder, and you'll hear from him as well. In the courtroom, I also have confinement status and pretrial supervision, and of course, I have the clerk of court who keeps the records in the courtroom. So when I call your name, I'm going to ask you to step up, and we will address everyone individually. So at this time, I'm going to start with Shanice Waller.
Ms. Waller is here, present, Judge at Maine. She is present. Come on up.
Okay. All right, Ms. Waller, you're before the court for one count of aggravated battery with a deadly weapon. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, the state's going to be requesting a $10,000 bond, no victim contact. I've been advised there was an arrest in '06 for aggravated assault. That charge was dropped. That prior arrest, based on the allegations that she cut the victim in this case with a knife, is the basis for the state's request.
Okay.
Judge, unfortunately, I haven't had an opportunity to review the PC affidavit, so I know what is written down in reference to the victim wanting to cooperate. My understanding is the victim does not want to go forward on this case. Having said that, Judge, right now, the alleged victim is who Ms. Waller lives with. That's who provides for her financially. She basically stays home. Right now, though, she is going to be looking for employment. She's 20 years old and living in our community for over 5 years. Judge, we're going to be asking, considering her lack of any financial resources, we're going to be asking for a $1,000 bond on Ms. Waller's behalf.
All right, I do find probable cause. I am going to impose a bond of $5,000, no victim contact until further order of the court. Chelsea Dixon. Oh,
Ms. Dixon is here present. Come on up, ma'am.
all right, Ms. Dixon, you're before the court for count 1, touch or strike battery. Count 2 is violation of felony probation. The probation is a no bond hold, and you will be before your division judge tomorrow at 8:30. I do find probable cause, and I will impose a bond of $1,000 on count 1.
Your Honor, would request
No
no victim
victim
contact.
contact.
Thank you, Judge.
Signing the orders. Mr. McLawrence, you have a client on page 12. Samuel Parles on page 12. He's represented by Mr. McLawrence.
He's in the main jail, Judge.
Okay. Mr. Parros, you're before the court this morning for two municipal ordinance violations, disorderly conduct, and resisting without violence. I do find probable cause. What does Mr. Parros wish to do?
Judge, he would like to resolve it. I didn't see his name mentioned anywhere else on the Broward County Clerk's website, so I'm not sure of any priors he has.
Okay.
But I was going to request that the court would give him a withholding contradiction notice of time that he served.
Okay. Okay, Mr. Parros, if you wish to resolve your case today, the sentence will be a withhold adjudication and court costs. Do you wish to resolve your case with that sentence?
Can you repeat the sentence for me?
Withhold adjudication, court costs.
Oh, yes, ma'am.
All right, as best as you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Parros, do you understand everything that's going on here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
You understand you have a right to go to trial. By taking a plea today, you're giving up that right.
Yes, ma'am.
And have you ever been treated for a mental or emotional illness?
No, ma'am.
And you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter, Mr. Parros? Guilty or no contest?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence serves withhold adjudication and court costs on both counts. I'll give you 6 months to pay your court costs. Good luck.
Thank you.
You're welcome. Carlene Florville. I'm sorry? Ms. Florville is before the court. Count 1 is aggravated battery with a deadly weapon, and count 2 is false imprisonment. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, state would be requesting a $5,000 bond on count 1 and a $2,500 bond on count 2, based on the level of violence alleged and in order of no victim contact.
I would just advise the court that Ms. Florville's daughters have been here since about 7:30 this morning when I got here, so they've been waiting all morning. So I think she obviously has very strong ties to the community.
Okay? Does Ms. Florville have any priors?
I do not see any, Your Honor.
Okay, all right. Mr. Romero?
She's been residing here in our community for over 30 years. She's 44 years old. Basically, she's a little emotional right now. She is grateful that her family's here for support. She's working. She works for Allied Universal. She's been working there for about, since October of last year, maybe about $12 an hour. Her financial situation, her family is who she's going to be depending on in order to post her monetary bond. I'm going to ask the court, she does realize I did explain to her as far as the no contact order. She will have no contact, she will abide by the court's order. But as you heard, this is her first contact with the criminal justice system. I'm going to be asking for a $2,000 bond on 1 and a $1,000 bond on 2.
All right, I do find probable cause. I'm going to impose $2,000 on each count. No victim contact until further order of the court. I'm sorry, ladies, did you wish to say something?
Just know we love you, Ma.
Okay.
It's gonna be okay.
All right, thank you. Michael Wimbley.
Mr. Wimley, come on up, please. He's approaching, Judge.
Mr. Wimbley, you're before the court for count 1 is a misdemeanor capias, and count 2 is battery, second or subsequent offense. The KPS matter is a possession of cannabis 20 grams or less. And the battery is from an affidavit from 2017, June of 2017. I do find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be requesting a $1,500 bond on count 2. This is a filed case. It was filed in, I believe it was 2017. It's prior conviction for battery on a law enforcement officer from 2011 and resisting without violence from '08. The state would also be requesting a no contact order until further order of the court.
Okay?
Judge, as far as the monetary bond, considering everything, that is reasonable. What I want to talk about and what I spoke to Mr. Wembley was probably going to be the issue is the no contact. As the court pointed out, this happened, I believe, in 2017. The alleged victim is here present. My understanding is they're living together. There's been no future incidents or anything like that. I do not believe she's not in no fear. She does want contact with Mr. Wembley. He's a provider. He just got hired. He works for ABC Roofing, where he's going to be making $14 an hour. He was scheduled to pick up his uniform, I believe, on the day he was arrested. They have 2 kids. They live in Fort Lauderdale. Their monthly rent is $650. My understanding is Ms. Birch relies on Mr. Wembley to provide for the family and provides emotional support and providing for the children. So, Judge, I'm going to be asking you, and I know it's a legal fiction, no harmful contact, but that's what I'm going to be asking, no harmful contact.
And, Your Honor, the only request I'd make is if the court is not going to issue a no contact order, then just to allow contact, no harmful contact, really isn't enforceable and can really cause more problems than assistance.
Okay. Ladies, is there something you wish to say?
Yes.
Can you, what is your name, ma'am?
My name is Bianca Birch.
And how are you related to Mr. Wembley?
I'm Mr. Wembley's baby mother / fiance.
Okay.
I have seizures, and I really need Michael around me. I do suffer with seizures, and I'm not going to be able to do it without him around.
There are many things that I have to take into consideration when at these first appearance matters, so I appreciate you being here. However, at this time, I do find probable cause. I am going to impose a bond, $1,500 already on count 1 on the KPS for failure to appear in court. Count 2, I'm imposing $1,500. And until further order of the court, I'm going to say no victim contact.
Your Honor?
Yes.
And I just want to put an offer out there, just can make the bond easier. If Mr. Wembley's interested, the offer on count 1 would be a withholding court cost. It's a 2011 case. I don't know if he's interested in resolving it.
Let me talk to him.
Sure.
So it's no way. It's basically he cannot be around me, period.
Not until another judge says no.
And, Your Honor, the one thing I would have no well, I'll wait till Mr. Romero's done talking to his client.
Judge, first, as far as the issue, as far as what the state extended their plea offer, Mr. Wembley does wish to accept the
What was the
state's
offer?
plea offer.
Withholding court costs
Okay.
on the cannabis. And
Withhold.
Okay.
The second issue is, sorry, there was a fly in here. The second issue, Judge, they share children in common. I believe Ms. Birch is the person that actually drops off the children at school, and Mr. Whip is the gentleman who picks them up. I know you made a decision as far as no contact. I'm asking in respect with the children. Can Mr. Burke be able to pick up the children and basically drop them off at their home?
I don't have,
Can that be accommodated? Okay.
and Your Honor, and the only other, based on the testimony that was given, I wouldn't have an objection if the court wanted to allow Mr. Wembley to provide financial support. If you wanted to send a check or anything like that, in the mail. I don't have a
The
problem
no
with that.
contact order does not prevent that, so
Well,
that's,
Sometimes it can be interpreted as any type of communications, even by mail, so
okay.
I just want to, on the record, I have no objection
All
to
right,
that.
you know, if you want to send money for the children, that's not, I'm not preventing him from doing that. All right, I'm just saying that there was a police report made, and until we've determined what's going on here, it's a no contact order otherwise, okay? All right, so, Mr. Wembley, you wish to resolve count one, which is the possession charge, is that correct?
Yes, ma'am.
And you heard that the offer was a withhold adjudication and court costs?
Yes, ma'am.
All right, please raise your right hand to the best of your ability. Do you swear or affirm to tell the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Wembley, you understand everything that's going on here today?
Yes, ma'am.
And is anyone forcing you to resolve this case today?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
And sir, have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir?
No content.
All right, I'll accept your no contest plea, find that it's freely and voluntarily given. Your sentence on the possession of cannabis charge is a withhold adjudication and court costs. All right?
Yes, ma'am.
And as to the other count, it's $1,500 and no victim contact.
150.
With the bonds. Good luck, sir.
All right.
Your Honor, yes. Thank you, Sheila, because I forgot.
Is that one of yours? Joseph something, Ray? I got it, it's Ray's.
Judge, could we call Mr. Joseph Reyes? He's on page 24 of the docket.
Yes, sir. Joseph Reyes on page 24. All right, Mr. Reyes, you're before the court. Count one is trespassing. Counts two and three are felony violation of probation. Those are no bond holds. Count four is an out-of-county hold for a misdemeanor charge. You have been ROR'd on that one. I do find probable cause, and as to the felony matters, you will be before your division judge tomorrow at 8:30. And the bond on count one is $25. Good luck, sir. All right, Mr. Shate, you're here on Sabina Woodrick on page 7.
Correct, Judge. She's in North Broward.
All right, Ms. Woodrick is before the court for its two misdemeanor capious matters.
So she's got two matters out of Deerfield Beach. Deerfield Beach would offer 2 times served on both of these matters.
All right, Ms. Woodrick, your attorney has received an offer from the city to resolve your case, which is adjudication and time served. Would you like to resolve your case with that sentence?
Yes.
All right. Please raise your right hand. Is swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Woodrick, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need more time to speak with your attorney?
No.
You understand you have the right to go to trial. By taking a plea today, you're giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
All right. What plea do you wish to enter?
No contest. Say no contest. That's what it is.
No contest?
There you go.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence will be adjudication and time served. I'll give you 6 months to pay your court costs. Good luck, ma'am.
Thank you.
The other matter I have, and I also have one on page 17, Hernandez Polanco. They're accompanied with 2 felony charges, so I would just ask that they be sent to the division. We don't need to go to them right now if you don't like.
Blanco, oh, we didn't pull those.
Yeah, I think just one was pulled. I'm sorry, I forgot to pull.
All right,
No, but-
so Joseph Amont on page 23.
Correct. He's got several other matters, Judge.
No, Broward, Your Honor.
Oh, okay.
Good morning, Your Honor.
Good morning, Mr. Amat. You're before the court for count 1, petty theft. Count 2, burglary for dwelling, structure or conveyance armed. Count 3 is aggravated assault with intent to commit a felony. Counts 4 through 7 are misdemeanor capious matters. I do find probable cause. And, as the
Ma'am,
bond, yes.
could I have a minute to explain the charges?
No, sir.
No, Mr.
We're
Amat.
not talking about your case today. See?
Oh, okay, so, but.
But don't talk about your case. All right,
Okay,
I'll
can you
hear.
take into consideration as a retired Air Force colonel and a rabbi since 1972 that I am trustworthy enough to be released on my own recognizance?
Well, you've got 1, 2, 3, 4 capious matters that you did not come to court. So,
Okay, I was never informed of any of those cases, ma'am, or else I would have appeared in court.
all right. All right, I'll state you wish to be heard.
Good morning, Your Honor. Allison Graber on behalf of the state. We are asking for no bonds on count 2 and one moment, Your Honor. No bond on count 2 and we've also provided a supplemental report to the court and to defense counsel. Yeah. What about the other one? Okay.
Mr. Shade, are you representing him? Oh, Mr. Reed, are you representing him on the other counts?
He's not actually filled out an application, but
Oh, okay.
we will represent him. Based on my conversations with Mr. Amat, I do not believe that he is in a position to retain private counsel.
Your Honor, I just came back from a 3-month tour with the Air Force Reserve in Korea, and I have numerous injuries from my battles in Korea. And in addition to that, I served with the Air Force for 48 and a half years as a colonel. I was made a colonel in 1974 by President Nixon because he took the lieutenant bars off of my shoulder and made me a full bird colonel in exchange for my actions in combat.
Is the state seeking proof evident presumption grade on
I'm
this?
not sure what I was reading.
Yeah, I
And
asked for no bond
and
on
if they
count 2.
review the physical evidence,
Okay, Mr.
Don't
Amat,
discuss
hold on
the
just a moment,
case, Mr.
okay? All
Amat.
right,
No, don't do anything with it. Yeah. Judge, I'd object to proof evident presumption grade
I
at this
didn't
stage of the
hear
proceedings.
a request
Oh.
for proof evident presumption.
Sorry, Your
grade.
Honor. I did. Am I on the record? Sorry, Allison Graber on behalf of the state. For count 2, we are asking for no bond. We're finding proof evident presumption grade that he did commit this offense.
We would object to the court making such a finding
what
at
are
this
we
point in
doing
time.
on
But for the
count
record, I
3?
have reviewed the extensive police reports involved in the case.
What are we doing on count 3?
Your Honor, the state was, in whatever order you want to go in, the state was going to wait for the court to make a determination on 2 before making a recommendation on 3. Frankly, either way, the state's recommendation on count 3 would be a $7,500 bond and no victim contact.
Based on my conversations with Mr. Amat, Judge, he couldn't make a $75 bond, so any bond that the court sets as far as the other counts are concerned, he will not be able to post. I have greater concerns than his bond, quite frankly, at this point.
All right, based on my review of this additional with the affidavit that I was previously provided, and then this additional report, I'm not sure that I know it looks like there were two parties. One was swinging a chair, one was swinging a bat. I'm not sure
Well, Your
what's
Honor,
going on here.
It would appear that the two victims work at a car wash. They live in a shed on the property. The allegations are, for some unknown reason, Mr. Ahmad tried to force his way into the shed where they lived. He was armed with a pipe at the time, threatening them. At one point then, yes, one of the individuals was defending himself with a chair from Mr. Ahmad, which I could frankly understand when someone, a complete stranger, armed with a pipe announcing that he's DEA, is trying to force his way into where you reside.
Where, is there any mental health concerns, Mr.
Yes, Your
Reedy?
Honor.
Yes, Judge.
And that's part of the reason why the state's asking for no bond at this time, based on the statements Mr. Ahmad has made in court today, statements made in this report. I don't know, and the allegations, I don't know of any release conditions the court could set at this time that can ensure the safety of the community.
Can I have one more sentence in my defense?
No, Mr. Amat.
Okay.
Don't
The
don't
physical
don't say
evidence-
don't say anything about the case, Mr. Amat.
Okay, I'm just saying, there's no physical
No, I'm
evidence
just saying,
against
don't say
All
anything
right,
about the
in
facts of
the-
the case.
In the second affidavit that I was provided by the state, the alleged victim, there's a third paragraph, Boyd refused to open the door, but the suspect, Ahmad, finally forced open the door, came inside swinging a metal pole. Boyd said that Ahmad kept yelling that he was DEA and that he should have opened the door. Boyd said that Ahmad, he did not know, never seen before, swung the pole to hit him, and so he kicked Ahmad. All right, I do find probable cause. I am going to make a further finding of proof evident presumption. Great. He's going to be held no bond as to count 2. And then on count 1, on count 3, I'm going to impose a bond of $2,000. No victim contact. Does, and I have no idea if Boyd lives at the place, so no victim contact, and I don't want to say no return if that's where Mr. Mott lives and not Mr. Boyd. So, all right,
Hey, Judge.
okay.
And Judge, can we have that, the misdemeanor or the MOs go to Judge Lerner on?
Which one? Oh,
The last 3, 5, 6, and 7.
okay.
And I suppose number 4 as well.
Aren't they, oh, okay, they're different.
Thank you, Judge.
All right. Anthony Rawls.
It's approaching, Judge.
Mr. Rawls, you're before the court for 1 count of domestic battery by strangulation. I do find probable cause. I'm going to hear from the parties as to bond.
Your Honor, the state would be requesting a $15,000 bond, pretrial release with a GPS monitor. Based on the allegations, this is also a filed case. Also, Mr. Rawls' criminal history, 2011 domestic violence battery and tampering with a witness or victim, those charges were dropped. 2010, arrested for domestic violence battery, that charge was dropped. 2010, arrested for aggravated assault with a firearm and domestic violence battery, those charges were dropped. He had another arrest in '03, battery and improper exhibition of a firearm, that was domestic in nature, those charges were dropped. Those 4 cases were allegedly against 3 different victims, separate and apart from the alleged victim in this case. 2010, an unlawful use of false name ID under the name Antoine Smith. Another unlawful use of false name ID in '02. Nothing further.
Okay,
Judge, in speaking with Mr. Rawls, first, I believe he was picked up yesterday on this offense. When was the date of incident on this alleged offense?
It's November 4th of last year.
Judge, also, Mr. Rawls doesn't know anything about the facts or circumstances regarding this incident. Having said that, Judge, he's not going to be able to afford what the state has suggested as far as monetary bond. He's 36 years old and living here his whole entire life. He is working. He's been working for the same company now for 2 years. It's called Ed Myers Produce, where he makes about $9 an hour. He lives in Pompano Beach. His monthly rent is approximately $800 a month. There's no way he's going to be able to afford what the state suggested. We're going to be requesting a $3,500 bond on Mr. Rawls' behalf, Judge.
all right, I do find probable cause. I am going to impose a bond of $10,000, no victim contact. And, okay. Twin Tone Hunter,
Judge, I've been advised he's in regular court.
okay? Donald George. Yes.
Hold on one moment, Judge.
Okay. All right, Mr. George, you're before the court because you have an out-of-state felony hold. I do find probable cause. You will be before the extradition court Tuesday or Thursday of next week, okay? Nastasia Buchanan. Bonded,
Judge, bonded.
all right. Jessica Zarakas.
Yes, ma'am.
No, Broward Jones.
All right, Mr. Zarakas, you're before the court for 1 count, possession of drug paraphernalia, and count 2 is violation of misdemeanor probation. You will be before your misdemeanor judge tomorrow at 8:30. I do find probable cause. Your bond on count 1 is $100, and the bond attached to the violation of probation is $1,000. Good luck, ma'am.
Judge, I had spoken to Ms. Zarakis earlier. She indicated to me a desire to admit to the allegations in the violation of probation if there was an offer extended.
She has court tomorrow. We'll just leave that for her division judge tomorrow.
Good luck, Jessica.
Betty Rosado. Okay, thank you. Sambria Canyon. Okay. All right, ma'am, you're before the court because you have 3 misdemeanor capious matters. I've been told that your bond has been posted, so good luck, ma'am.
Thank you.
All
Your
right.
mom is going to be waiting for you. I spoke with her earlier, okay? Good luck.
Okay, thank you.
Tynesha Edgerton. Thank you. Ma'am, you're before the court for 1 count of driving while license suspended, habitual, and count 2 not for magistrate is failing to provide proof of insurance. I do find probable cause. What does Ms. Edgerton wish to do?
I was going to be asking the court for an ROR. I did leave a message for her mother. She was under the impression maybe her mother had posted her bond. I don't know if the confinement status shows anything having been posted.
Do we see any bond posted for Ms. Edgerton? Meantime, State, does she have any priors or any?
Is she, I mean, obviously, she's had multiple DWLSs. Based on the amount of DWLSs she's had, I'd count at least 4. I'd be requesting, I don't have an objection to non-monetary release, but I would be requesting pretrial.
Hasn't been posted yet? All right,
Judge, I'd be asking for a straight ROR. She's lived here all her life. She's been living in the same location for 3 years. She has 4 children, aged 14 to 6. She has her own apartment. Her rent is that $1,095. She's been working for the school board in the cafeteria since last year, so she has a steady job. And I think she's a good candidate to return to court.
Your Honor, and just part of the request is also that, considering that this involved a crash.
all right, I'll grant Ms. Edgerton ROR on this count.
Thank you, Judge. Don't miss court, Miss Edgerton.
Thank you.
Bria Thigpen. Yes. Ma'am, you're before the court. Count 1, resisting officer without violence. Count 2, operating without a valid driver's license. And count 3, false ID given to law enforcement. Count 4 is also an out-of-state felony hold. That's a no bond hold. And so you should be going to extradition court on that matter. As to the other counts, I do find probable cause. Your total bond is $100. I don't. I don't know the status of the out-of-state case, so
It
I will.
looks like,
Yeah, I see that, but
it looks like it's on a probation warrant.
it's on a probation.
That's what I'm looking at here from Westchester County.
All right, so. All right, so your bond is $100. If there's anything else, I guess they'll send her back. I don't know.
Well, I wouldn't encourage her to enter a plea because it's a
Well,
probation
that's what I'm
matter.
saying.
Right.
That's what I'm saying. Estefania Ruiz Marquez.
Also Paul Ryan.
All right, ma'am, you're before the court, burglary with assault or battery. I do find probable cause.
Your Honor, I'm going to be requesting a $5,000 bond and no victim contact on this punishable by life offense. Noting the strength of the evidence, the victim provided cell phone video of the incident, and according to the report, the sworn report, Ms. Ruiz Marquez agreed to the above described events of the incident. Would also be requesting no victim contact since it appears the two parties are known to one another.
Yes, apparently the victim came to Mr. Ruiz Marquez's residence, which is where this incident took place. I didn't ask her, can you make a $5,000 bond? Can somebody come up with $500 to bond you out?
To be honest, no.
First, it doesn't say Mr. Ruiz Marquez's residence, it says Mr. Silva's residence. It also says that the victim and him have been dating on again and off again for the past 2 years, so I don't want it to seem like she was going to that residence looking to instigate anything with Ms. Ruiz Marquez. That does not appear to be the case.
I am going to impose a bond of $5,000, no victim contact.
I'll call your mom, okay?
Okay, thank you.
Okay, good luck.
Do we have Jennifer Shelley today?
Yes, we do, Your Honor, for
Okay. All right, ma'am, you're before the court. Count 1 is possession of cocaine. Count 2 is possession of heroin. Count 3 is possession of drug paraphernalia. Count 4, obstruction by disguised person. Count 5, unlawful possession of personal ID of another. And 6, 7, and 8 are felony violation of probation. And I do find probable cause. As the 6, 7, and 8, you do have a no bond hold.
I just asked the court to leave the other bonds in place.
Looks like your violations are out of Palm Beach County. So I do find probable cause, and I will leave the bonds in place as to the other counts.
I had, so I was arrested on April 1st. On April 2nd, I had a Marchman Act. My father petitioned the court for a Marchman Act. I was supposed to be in court yesterday for that. Because my dad and my treatment center are trying to get me to go back into treatment. But I haven't been able to speak to anybody yet since I've been in jail.
Okay, you'll speak with your attorneys. You were on medical reset for the past 3 days, so I think now somebody will be able to come and speak with you. Okay? All right. Okay, Vidish Guberdon.
He's here present, Judge Amin.
Just means no charge, no bond needs to be.
Sir, you're before the court for trespassing, occupied structure, or conveyance. I do find probable cause.
Judge, I'm gonna be requesting an ROR on Mr. Goberham's behalf. I don't know if the state has an objection.
Looks like he resides in New York. So, yeah, I do.
And I don't know. Based on the allegations here, you know, it seems like it appears to be a simple, you need to go outside because we're doing tests and he's refusing. So I don't have any confidence that he's gonna come back. So I'm gonna leave, you know, if I ROR
In
him.
that case, Judge, I'm gonna ask you to consider reducing the bond from $100 to $40. When he came in, I believe he had that amount, so he could self-bond.
That's all I have.
All right, bond is $40. Ian Schulman.
Mr. Schulman's approaching, Judge?
So Schulman, you're before the court for a misdemeanor capious matter. It's It's a failure to register vehicle. I do find probable cause.
Judge, Mr. Shulman, in speaking to him, he believes he may have already resolved this case. I don't know if we can look in Odyssey and see if we have. And that, he believes he resolved it in magistrate court.
January 8th.
They're gonna look.
I was given pre-trial release.
Well, if it was given pretrial release, it wasn't resolved. He failed to appear in court on February 11th, 2019 for his arraignment.
Judge, yeah, from what he just explained to me, if he was given pretrial release, then obviously he didn't resolve this case. So, at this time though, he wanted me to ask court, if it's not resolved, does the state have a plea offer on this case?
Offer to be a withhold.
Okay?
He wishes to accept the state's offer, Judge.
All right, Mr. Schulman, please raise your right hand. Do you swear or affirm to tell the truth, sir? Okay.
Yes, ma'am.
Okay, you can put your hand down. Do you understand everything that's going on here today?
Yes, ma'am.
And today you understand that you are resolving the case today?
Yes.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter, sir?
No contest.
All right. I accept your no contest plea. I find that it's freely and voluntarily given. And we did say withhold, right?
Yes, ma'am.
Withhold adjudication and court costs. Good luck, sir. Ferdinand DePhillips.
He's approaching, Judge.
All right, Mr. DePhillips is before the court for exposing sex organs in public. I do find probable cause.
Judge, Mr. DeVillips advised, well, he's homeless. He advised me that nobody financially can post his bond, so we're requesting Mr. DePhillips be released on warrant.
If that's gonna be denied, do we need to transfer this to Judge Lerner Wren?
It's fine with me if that's what the defense would like that. That's fine with me.
It may be a good idea, Judge.
All right, I'll sign an order to transfer to Judge Lerner Wren. Reed Stiers.
He's approaching, Judge.
Mr. Stiers is also before the court for exposing sex organs in public. I do find probable cause, and
Judge, it's being Mr. Stiers. He's homeless, but he does have a mailing address. We're going to be requesting an ROR or to be released on pretrial release on his behalf.
I have a job. I'm not going anywhere. Do that. I'll pay the fine because,
Hold on.
and as to Mr., it is Stiers, correct?
Yes, ma'am.
As to Mr. Stiers, is there any mental health concerns?
I don't have any right now, Judge.
All right, I'll release Mr. Stiers then to pretrial supervision, standard. Brian Burton.
Yes, sir. Mr. Burton, come on up, please. Brian Burton. Oh, he just went to the restroom. Judge, can we
All right.
brief call while he comes on?
That's fine. Devin Smith.
Mr. Smith, come on up, please. Person, Judge.
Mr. Smith, you're before the court for a traffic capias matter. It's a driving while license suspended. You failed to appear at arraignment.
Judge,
Yes.
in speaking to Mr. Smith, what he advised me this past Monday, basically through all his savings, he managed to get pay all fees associated with trying to reinstate his license. which he informed me he did on Monday. I'm gonna be asking the court to consider an ROR on Mr. Devin Smith's behalf. My understanding is also the court date that he missed, he was in custody in Leon County, so he didn't voluntarily miss. But the most important part about it, from what he told me, was he managed to get his license reinstated. And that's the reason I'm asking for the court to consider an ROR on his behalf, so he can go to court and show potentially the court and the state valid license.
Okay. Do we have any record of that?
I'm pulling his driving record right now.
Okay.
My understanding, he said, I believe it was initially suspended for court fees, so he had to rectify that situation, and he paid almost close to, I think, $2,000.
Okay.
Yeah, I'm showing his license has been reinstated, Your Honor.
All right, I'll RR Mr. Smith then. Good luck, sir.
Thank you, Judge.
Terrence Singleton,
Mr. Singleton's approaching, Judge, and whenever you have an opportunity, Judge, Mr. Burton is back from the restaurant, and Mr. Singleton declined the services of public defense.
Don't focus on that.
all right, Mr. Singleton, you're before the court for a misdemeanor KPS matter on a possession of cannabis 20 grams or less charge. This is an old KPS from October 26, 2017 that you failed to appear in court. So, what do you wish to do today, sir?
I'm gonna pay for the bond. I think I've already posted for bond.
Okay, all right, I do find probable cause, you know, the bond is $500, somebody's working on that?
Yes, ma'am.
All right, good luck, sir.
Thank you.
Jose Martinez Perez,
Mr. Perez, come on up, please. Oh, and Mr. Burton is here present.
oh, all right, after Mr. Perez, I'll. All right, Mr. Perez, you're before the court, count 1 is the DUI, count 2 is DUI with, a level greater than .15, count 3 is DUI with, damage to property or person of another, and count 4 is failure to use due care. I do find probable cause, and I'll hear from the parties as to the bond.
One moment, Judge. Nothing to add at this time, Judge.
All right. All right, the standard bond's in place. Good luck, Mr. Perez. And then Brian Burton,
Mr. Burton, come on up, please.
Mr. Burton, you're before the court for possession of drug paraphernalia. I do find probable cause.
Judge, in speaking to Mr. Burton today, he wishes to resolve this matter.
Okay,
Offer be time served, Judge.
all right, it's an adjudication and time served, sir.
He wishes to accept the state's offer.
All right, as best as you can, raise your right hand. You swear affirm to tell the truth?
Yes.
All right, sir, you understand everything that's going on here today?
Yes.
And do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
You understand you have the right to go to trial. By taking a plea today, you're giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter, Mr. Burton?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Hello, sir.
Is Mr. Green still on medical loan?
Yes.
And Darren Davis?
Mr. Davis is approaching, Judge. He's here. Come on up, sir.
All right, Mr. Davis, you're before the court for a misdemeanor capious matter. Operating without a valid license is the charge. I do find probable cause. What does Mr. Davis wish to do?
Judge, in speaking to Mr. Davis, he wishes to resolve the matter today.
All right, state.
Offers to withhold court costs.
Okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Davis, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Davis, do you understand everything that's going on here today?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
You understand you have the right to go to trial. By taking a plea today, you're giving up that right.
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs. Good luck.
Thank you. Appreciate it.
Chesdin Murray.
Mr. Murray, comment, please.
All right, Mr. Murray, you're before the court today for an add charge. This is charge number 4, trafficking in fentanyl, 4 grams or less than 14 grams. I do find probable cause. I assume Mr. Murray is in custody on other counts?
Correct, Judge, he has no bond hold.
Yes, Judge, counts 2 and 3 are no bond holds.
All right. So, Mr. Murray, your bond on count 4 is $75,000. Good luck, sir. Arthur Antoine.
Judge, Mr. Antoine is approaching. He has private counsel. I believe my colleague may have attempted to contact him.
I did. I spoke with the office of Pedro.
The office of who?
Pedro.
Pedro.
They indicated they do represent him. The secretary was going to text him with the courtroom number, and I don't know if he's going to be coming by or not. I do know that Mr. Antoine also has no bond holds in addition to the count 7 that's before the court this morning.
I can't hear nothing.
All right. Sorry, Mr. Reedy. He didn't hear.
Not too many people complain about not being able to hear me, I will say that. But I don't know if Mr. Pedro is coming or not, Judge, is the bottom line.
Okay. So, did you heard that, Mr. Antoine? We made a phone call. We sent the information. We haven't heard back from the attorney. So you're before the court today. This is charge number 7. It's trafficking in fentanyl, 28 grams or more. Okay? And I assume that Mr. Antoine is being held on other charges at this time
Yes, Your Honor, he has some no bond holds.
with no bond hold. So your bond on this first-degree felony is $500,000. Good luck, sir.
What?
James Isaac.
What's DTA?
He's here, present, Judge.
Mr. Isaac, you're before the court today. It's add charges, charge number 2 and 3, grand theft, and 3 is damaging your electronic monitoring device. I do find probable cause, and I'll hear from the parties as to bond.
Judge, nothing to request from the defense. My understanding is he has a no bond hold on count 1.
Okay,
So he's gonna have to go in front of his division judge to seek some sort of relief anyway.
all right, so the bonds on 2 and 3 are $1,000. Good luck, sir. Edward Casey,
He's approaching, Judge.
Mr. Casey is before the court for count 1, possession of methamphetamine, count 2, unlawful possession of personal ID of another, count 3, possession of drug paraphernalia, counts 4 and 5 are traffic infractions that are not for magistrate. I do find probable cause.
Judge, I'm gonna be requesting the court consider releasing Mr. Casey, straight ROR. He's 40 years old, been living in our community since 2008. He lives in Fort Lauderdale, an apartment he just moved in. He gets disability. My understanding, Judge, is he's a veteran. He served in the United States Army from 1998 to 2008. Judge, I believe he has very, very, very limited contact with the criminal justice system. Considering this is a nonviolent offense, that is why I'm asking for Mr. Casey to be considered to be released ROR.
Okay,
Your Honor,
yes, ma'am.
Mr. Casey is currently on pretrial supervision in case number 17001645 CF10A, possession of methamphetamine. At this time, pretrial is requesting a revocation of his supervision.
Okay,
Judge, Mr. Casey seems surprised he's not aware that he's out on the case.
okay.
That's really weird because he got court notice in court on February 25th by Judge Merrigan for that case.
And he was released February 11th.
Judge, I don't know what to tell you. Mr. Casey seems confused by the situation.
All right, so as to case number 17001645 CF10A, Mr. Casey is on pretrial supervision for possession of methamphetamine. I am going to revoke his pretrial supervision. He's going to be held no bond on that charge until he goes before his judge. And then as to the new arrest, which also includes possession of methamphetamine, his bond is $1,000. Joan Hernandez Polonico.
No problem.
All right. Yes, thank you. Sir, you're before the court for 1 count of criminal mischief, and count 2 is a misdemeanor capias.
Wow.
As I told you, Mr. Hernandez, please do not discuss the facts of your case.
All right, I do find probable cause. Does anyone wish to be heard?
Mr. Hernandez, Polanco indicated to me, Judge, that he does not have any money at all. He's completely destitute and indigent. He cannot make the bond on the municipal ordinance, and he can't make the bond on the criminal mischief.
Okay,
And I know that there's an issue of restitution, so we're probably not going to be able to, the only thing I can ask is if the court would offer him something on the municipal ordinance and put him on pretrial release on the felony.
Well, Mr. Polonica, would you want to resolve the KPS, the misdemeanor matter? That's an open container, is it an open container? Yes. It's an open container charge. And then we'll have to set a bond on the criminal mischief matter. What do you wish to do?
So,
Did you hear what the judge said, sir? Mr. Hernandez Polanco, did you hear what the judge had to say?
Yes, yeah, man. Yes, sir. Yes, sir.
What would you like to do?
They're here, I don't got no choice. You know, they're here, come back again in the court. Give me a, I don't know.
All right,
Up
I'm
there.
I'd
gonna
ask the
leave the
court not-
bond,
yeah.
I'm gonna leave the bond in place at this time. All right, good luck, sir. Douglas Farmer,
He's approaching, Judge.
all right, Mr. Farmer, you have one count of battery on an officer. I do find probable cause. What does Mr. Farmer wish to do?
Judge, I'm gonna be requesting Mr. Farmer to be released on pretrial release. He's homeless, he's financially indigent, and I'm gonna be asking for a photo order as well.
Your Honor, I'm requesting a $1,500 bond. Mr. Farmer just appeared before you on Monday. He resolved a theft and trespass at that time. Before that, he was arrested March 14th on municipal ordinances. October 9th of last year, just keeps coming back before the court. And today, and on this case for allegedly putting his hands on a police officer.
All right, Mr. Farmer, your bond is $1,000. Herbert Coakley? Sir, you're before the court for one count of possession of cocaine.
Yes, ma'am.
I do find probable cause. As to Mr. Coakley.
I'm going to ask the court to consider a pretrial release for Mr. Coakley. He's been living in Florida since 1985. He's been living for the last 7 years with his mother. Unfortunately, he does not currently have a job because he receives SSI for a disability, which has made it impossible for him to save up any money or to work. He did indicate to me he thought that his mother was going to be bonding him out. I haven't been able to reach her this morning. I don't know if maybe confinement status shows the bond was posted. But I don't know how much confidence I have in that situation.
Your Honor, I don't believe Mr. Coakley would be a good candidate for pretrial. 2013, he had felony battery, domestic violence by strangulation, aggravated assault with a deadly weapon. He was sentenced to 5 years in a day state prison as a habitual offender and a PRR offender. 2008, violation of a domestic violence injunction. 07, false imprisonment, felony battery due to priors. 2 counts of battery on a law enforcement officer and resisting with violence. He was sentenced to 32 months in state prison as a habitual offender. 08, violation of a domestic violence injunction. Loitering and prowling, resisting without violence. 07, he's gone to prison for violence multiple times prior to that as a habitual offender. Gone to prison for delivery of cocaine. Had prior conviction for battery. Multiple convictions for battery. Michelle, does it show? When? Yes.
All right, Mr.
considering-
Coakley, your bond is $1,000. Good luck, sir. Richard Concepcion.
Approaching, Judge.
Mr. Concepcion, you're before the court for grand theft auto.
okay.
I do find probable cause.
I'm gonna be asking for pretrial. I'll ask, the state if, they have an objection to that.
Oh, yes, we object to pretrial release. He was,
In that case, Judge, he's 24 years old, he's working in construction, he lives in Oakland Park where, he lives with a roommate. His roommate cannot afford to post his monetary bond, because from what he told me, his roommate's going through a separation, which, is becoming a financial strain on him, so nobody's gonna be able to afford to post his monetary bond. Judge, I haven't seen the PC affidavit, but from what I've been informed, I believe this isn't a typical grant. That my understanding is, the victim and Mr. Concepcion, know each other. They had an agreement in which he would be renting a U-Haul for Mr. Concepcion. I believe he was late on one payment. He thought he came to an agreement with, with the alleged victim, telling him that when he gets paid by, a customer doing construction, he would be reimbursed. So Judge, at this time, that's why we're asking for pretrial release on Mr. Concepcion's behalf.
Your Honor, the state's requesting a $2,500 bond. This is Mr. Concepcion's third arrest in Broward since March 20th. He was arrested March 20th on a capias for leaving the scene of an accident. He was ROR'd. He was then arrested March 26th for possession of MDMA, and he was ROR'd on that. And now he's before the court again.
All right, Mr. Concepcion, your bond is $1,000. Good luck, sir. Lucas Sebastian Lopez.
What's that?
Judge, bonded, Judge, bonded.
All right, thank you. Yves Laurent Van Key.
Mr. Benke? No, that's good.
Sir, you're before the court this morning. Count 1 is possession of cannabis, 20 grams or less. Count 2 is possession of cocaine. Count 3 is possession of drug paraphernalia. Count 4 is resisting officer without violence. Count 5 is driving while license suspended. Count 6 is leaving the scene of a crash involving damage. Count 7 is possession of open container. Count 8 is vehicle with no lights, and count 9 is no tag light. Those are not for magistrate, those are traffic infractions. I do find probable cause, and I'll hear from the parties.
Judge, nothing to request from the defense.
Okay? All right, Mr. Vanke's bond is $1,000. All right, on page 27, there's Everton Dove, someone in the courtroom.
There is someone here for Mr. Dove. if he cares.
Sir, you're before the court. Count 1 is driving while license suspended, third or subsequent offense. Count 2 is an expired vehicle registration over 6 months. Count 3 is a felony violation of probation. That is a no bond hold before Judge Merrigan. And you should be going to Judge Merrigan's division tomorrow at 8:30.
Judge, is it Merrigan or is it McCarthy?
Oh, my information, well,
'Cause I don't want to
It says
send his,
Merrigan.
friend
Well,
in the
my
wrong-
information says Merrigan, so if you know something different.
Let me take, thank you, Judge. Odyssey doesn't say.
It's Merrigan, the clerk says it's Merrigan.
Yeah.
All right? Okay, good luck, sir.
All right, it might be.
Alfred Cockrell,
Mr. Cockrell is approaching, Judge, you see our name?
all right, Mr. Cockrell, you're before the court for count 1, burglary, unoccupied conveyance, unarmed, and count 2 is possession of drug paraphernalia. I do find probable cause. Anyone wish to be heard as to Mr. Cockrell?
Judge, just want to let you know, unfortunately, Mr. Cockrell is financially indigent. He's homeless. He has no one that can help post his bond. He's not working at this time. He advised me right now he has some physical issues which prevents him from work. Based on the fact that nobody can, because of his financial, Judge, we're going to be asking for the court to consider releasing him on pretrial release. And I'm going to also be asking the court to sign a photographic order so we can photograph the injuries that Mr. Cockrell sustained.
Okay.
The state's asking for a $5,000 bond. He has priors out of DC, Virginia, Maryland, and New York with prior failure to appear to court. He also has cases in Palm Beach, Dade County, and Monroe County. In 2019, it was a trespass in Palm Beach and drug paraphernalia case. Dade County, 2018, 2 thefts, trespass, and drug paraphernalia. Monroe County in 2018, theft. And it looks like he's transient.
All right, as to count 1, Mr. Cockrell's bond will be $1,000. Keno Bryant.
Mr. Bryant, bonded, Judge.
Okay. Ford Allen.
He's approaching, Judge. He declined to serve as a public defender. What case?
Mr. Allen, you're before the court. Charge 1 is violation of felony probation. That is a no bond hold. Count 2 is a misdemeanor capias. There is a $500 bond attached to that on a battery charge. And then count 3 is it's a civil writ before Judge Rebus, and that's not for magistrate. So I do find probable cause, and you will be before your felony judge tomorrow at 8:30, okay?
Okay.
All right, good luck, sir. Jordan Boucher. All right, Mr. Boucher, count 1, you're before the court for count 1, possession of THC, count 2, possession of cannabis 20 grams or less, count 3, possession of drug paraphernalia. And I do find probable cause.
Judge, I'm going to be asking for the court to consider releasing Mr. Boucher, ROR. Before I proceed, I'll see if the state has an objection.
I have no objection.
Okay, I'll grant the ROR. Michael Bonito.
Judge, I report you bonded.
Thank you.
Oh, no, I was just gonna read
Roland Allen,
Mr. Allen, come on up. He's approaching, Judge.
okay.
He's approaching, and he declined to serve as public defender.
All right, Mr. Allen, you are before the court for driving while license suspended. I do find probable cause, and I've also been told that your bond has been posted. Good luck, sir.
Thank you very much, ma'am.
Okay. Mitchell Berlanga. Mr. Berlanga, you're before the court. Count 1 is leaving the scene of a crash involving damage to property. Count 2 is fleeing with disregard for safety. And count 3 is burglary on occupied dwelling unarmed. Excuse me. I do find probable cause. I now hear from the parties as to bond.
I'm looking up stuff if you want to go.
It's for 10K. Wait. Oh. Should I say it now? Okay. On count 2, the state's asking for a $3,500 bond, and count 3, the state's asking for a $10,000 bond. He does have prior cases in Dade County, 2014, a grand theft, and in North Carolina in 2017, obtaining or identity theft. And also the house that he did break into to hide into while fleeing the police was occupied. And that's about it.
Judge, I'm going to be requesting a bond of $1,000 on count 2 and a bond on 3 of $5,000, requesting a total of $6,000 on Mr. Berlanga's behalf. Right now, unfortunately, he's unemployed. He can't work because of health reasons. So right now, he's being helped by his fiance. She's self-employed. She buys clothes and sells clothes online. They happen to live with her father in Miami Lakes. Grandfather, I believe, actually, and he's an elderly gentleman. So his financial resources are limited. So that's why he believes that his family can come up with $6,000, and that's the reason of our request. And we're going to be asking for a photo order so we can photograph Mr. Berlanga's injuries.
A couple things. didn't see this at first. Mr. Berlanga has a previous burglary of a dwelling at a Dade County in 2008. I would also note, I believe Mr. Romero brought up physical, medical conditions to Mr. Berlanga, but I would note, based on the allegations, he crashed his ATV, flipping it over, and was able to walk away from it to go break onto someone's property and hide from law enforcement.
All right, I do find probable cause. The allegation, the affidavit says that he was riding without a helmet, and then when the light changed, he rode a wheelie on his back tires as he went through the intersection. And then he went into someone's home when hiding from the police, the law enforcement. I do find curtilage, okay? I do find probable cause, and his bond on count 2 will be $3,500. Will be $5,000 on count 3. I don't, no return, no contact. Kenzie Davis.
He's here present, Judge.
Mr. Davis is before the court. Count 1, possession of cocaine. Count 2, possession of cannabis 20 grams or less. Count 3, possession of drug paraphernalia. Count 4, attaching registration license not assigned. Count 5, driving while license suspended. And count 6, not for magistrate. I do find probable cause.
Judge, speaking of Mr. Davis, he believes someone's going to be posting his bond. In fact, it may have already been posted. Is there any way to check to see if confinement status can tell us if it's been posted or not?
Okay. It's not showing in the records yet. His bond is $1,000. Raymond Arroyo. Okay,
Judge, Mr. Arroyo bonded.
thank you. Eugene Morel.
Mr. Morel is here present and approaching, and he declined to service as a public defender.
Your Honor, can we put this on brief recall?
Are we waiting for someone?
If I could proffer,
What?
I spoke with, if you look at the PC affidavit, it says approximately 4 grams. I spoke to the detective and I told him approximately is not good enough. He's literally printing out a supplement to send me right now with an exact weight.
All right, Mr. Morel, we'll recall you in a moment. William Boyd.
So I'll call it. All right. Down. Mr. Boyd is approaching.
Mr. Boyd, you're before the court. Count 1 is possession of cannabis 20 grams or less. Count 2 is selling cannabis within 1,000 feet of a school or park. Count 3 is trespass, armed structure, or conveyance. I do find probable cause.
Judge, I'm going to be requesting a bond reduction on count 2 from $5,000 to $2,500. Being Mr. Boyd, he's been here his whole entire life. He's 23 years old. He just got a job. He's going to be working at a restaurant called The Wilder as a This one. And cook. He's gonna have, several tasks to do at that restaurant, Judge. He lives in Fort Lauderdale with his mother. His mother is on a fixed income on disability. Now, he's already reached out to his family. They're gonna try and post his bond, but they're, from what they told him, they're not sure if they can afford full amount. So that's the reason why I'm asking for a bond reduction on count 2 from 5,000 to 2,500. And on count 1, the misdemeanor possession of cannabis, I'd ask for the court to consider an ROR, so making it a total of $4,000 bond on his behalf.
I could do a little better. I have no problem with the 2,500. Your Honor, the count 3 was a misbook. If you look at the PC affidavit, the officer charged him with trespass, not armed trespass.
All right.
It's even better.
All right. Count 1, ROR. Count 2, $2,000. Count 3 is no PC.
But Your Honor, I would ask the court to find PC for trespass. It's just what,
No PC for trespass armed. Also, PC for trespass. ROR, I'm on count 3.
Good luck, sir.
No, I put it on there. Ronnie Hamby,
Mr. Hamby is approaching.
Mr. Hamby, you're before the, oh.
He's here present.
Mr. Hamby, you're before the court for 1 count of possession of cocaine. I do find probable cause.
Judge, it's being Mr. Hamby. He gave me the phone number of his boss, of his employer. I intend on calling him right after court to post his bond. He believes that his employer would be able to post his bond.
All right, $1,000, good luck, sir.
Thank you. Good luck, sir. I'll call him right when I get out of here.
Okay, Brandon Woolery.
Mr. Woolery, come on up.
Judge, could we recall this? I'm still reading over the affidavit.
Oh,
All right,
we're gonna recall you, okay?
Kevin Mohal.
Judge, I'm gonna need a brief second to speak to the next 3 gentlemen.
Okay,
Mr. McCall, Mr. Mohall, I'm sorry, Mr. Pino, Mr. Lloyd.
okay.
Thank you. Judge, thank you for giving me that opportunity. I'm ready to proceed whenever the court is.
Okay. All right. Kevin Mulhall?
Mr. Mohawk? Mr. Mohawk? Come on up, sir. Sir, that's.
All right, Mr. Mohall, you're before the court. Count one is possession of THC. Count two is possession of controlled substance without prescription. And count three is possession of cannabis, 20 grams or less. I do find probable cause.
Judge, my understanding, Mr. Mohawk, he's 18 years old. He's a senior at a local high school here in Broward County. If the state can verify that he has no prior contacts with the criminal justice system, I'm going to be asking for the court to consider releasing him ROR.
I see no history, Judge. A little bit.
All right, I'm gonna deny RR. I'll release him to pretrial supervision
Judge,
with,
in that case, Judge, I'm going to ask you to leave the standard bond in place. He gave me the phone number of his father, who I intend on calling after court done.
okay, I'll leave the bond in place.
And Your Honor, just to let you know, anytime you want to call Mr. Murrell's case, I'm ready to
Okay.
proceed.
Jorge Pino? Mr. Pena is before the court. Count one, possession of controlled substance without prescription. Count two is possession of drug paraphernalia. And count three is resisting officer without violence. I do find probable cause.
Judge, we're going to be requesting pretrial release for Mr. Pino. He's 47 years old, been here almost his entire life for about 45 years now. He's working, he works for a plumbing company, been working there for a number of years, making about $100 a day. He lives with his mom. His mom, from what he informed me, he's not going to be able to post his bond. She works in a cafeteria as a cashier. Considering these are non-violent offenses, he does have contacts with the criminal justice system, but I believe it's been almost 2 years. So we're going to be asking for pretrial release.
Your Honor, state would be objecting to pretrial release. Mr. Pena has 7 previous felony convictions and was released from state prison June 15th of 2017.
In my understanding, and right now Mr. Pino is confirming, since 2017, Judge, he hasn't had an encounter with law enforcement or been arrested. That's why I'm asking for the court to consider releasing on pretrial release.
Denying pretrial release, Mr. Pino's bond is $1,000. Joseph Lowe? Mr. Lowe is before the court for count 1, petty theft, count 2, possession of oxycodone, and count 3 is possession of drug paraphernalia. I do find probable cause.
Judge, Mr. Joseph advised me that he spoke, I believe spoke grandmother, so it may have been posted. Can confinement status check to see if his bond's been posted?
It's not showing.
Judge, and that's what Mr. Lowe's concern is, that he said his grandmother was gonna try and post his bond. She's on social security, fixed income, so didn't post his bond. He believes that maybe she just couldn't come up with the money. So Judge, I'm gonna be asking for Mr. Lowe to be considered to be released on pretrial release.
The state has no objection.
All right, Mr. Lowe, you'll be on pretrial supervision.
So this is a matter of pretrial. You'll be released today. As soon as you get out, you have to report those across the street. Follow the arrow. If you don't report, there's gonna be a warrant issued for your arrest.
Call Mr. Woolery anytime you want, Judge.
Do we have Kirby Telson here today? Still on medical loan?
Do you know if a PC determination's been made?
It doesn't appear. I don't know how many times he's been reset, so I don't know. Mr. Reed,
It looks like he's been reset Sunday, Monday, and Tuesday now.
okay.
Here on Wednesday.
All right, I'll make the finding of probable cause, and we'll have to bring him back for bond. How about Eddie Rancher?
Medical research, Your Honor.
Okay.
I believe Your Honor found PC on
On Mr. Rancher, yes. On Ethan Hopkins?
And again, Your Honor, I'll be asking, based on the allegations in the report, I don't know if he's gonna be coming back anytime soon. So I'd ask the court to make a PC determination. He'll have to come back either for finding proof evidence or presumption or having a bond.
All right, I'll just make a probable cause finding. Miguel Romero?
Conti?
All right, Mr. Romero. This is an ad charge for an aggravated assault with a deadly weapon. So this is now charge number 4.
Your Honor?
Yes.
I believe, first off, I believe he has no bond holds. The second count is for a second alleged victim. Your Honor set the bond on the first count of aggravated assault at $10,000, so I would just be asking that you set the same $10,000 bond for the second victim.
In light of the no bond hold, Judge, Mr. Romero's gonna have to go in front of his division judge.
All right, so I do find probable cause and the bond is $10,000. Good luck, sir. How about Irvin Combs?
Main jail, I think.
He's here, President.
All right, Mr. Combs, you're before the court. Charge number 2 is felony battery resulting in bodily harm. Count 3 is firearm by a felon. And count 3 is false imprisonment armed. Count 4. So you have 2, 3, and 4 as additional charges.
Judge, these are change of charges.
They're all change of charge or not?
They're all change of charges. They're, for the most part, pretty lateral. He's got no bond holds in addition to these. The aggravated battery was an up-file from a felony battery. That being said, bond was originally set at $5,000. I'm fine with that $5,000 being placed back on that count. The firearm by felon charges was $5,000. I'd ask that that bond be kept in place. Your Honor set the false imprisonment at $10,000. It's now been filed as an armed false imprisonment. I'd ask that the same $10,000 bond be kept in place. You also ordered pretrial with GPS and no victim contact, so I'd ask that those release conditions remain.
All right.
Judge, I believe the state said he has no bond holds. So at this time, Judge, nothing to add by the defense.
All right, so count two's 5,000, count three 5,000, count four 10,000 with GPS and no victim contact.
Okay, thank you.
And Alex Bernardin,
Judge, he's approaching as private counsel, Mr. Mickey Roque.
all right. Mr. Bernardin, do you know if your attorney knows that you're in court today?
I don't know.
When did you retain Mr. Roque? Did he file a notice of appearance? He did? Okay.
And frankly, I doubt if Mr. Roque knows he'd be here this morning.
Right,
because-
let's, if someone can give me his number, I'll make a phone call.
One-
You did what?
I said, I just found out 2 seconds ago that Mr.
No,
Roque-
that's okay.
let me
So,
find
so Mr. Bernardin, have a seat, and we'll try and call your attorney to see if he has any input.
I have it, Judge.
Okay,
954
okay?
854 7554.
Thank you.
Hello, it's Mickey.
Mr. Roque, this is Judge Jackie Powell. I'm calling from open court.
Hey, Judge.
First appearance. Hi, how are you?
I'm good, thanks.
All right, I have Alex Bernardin, who's before the court today, for first appearance. There's been some, there's a change of charge. I know you represent him, and so I didn't know if you were in the courthouse, if you wanted to come by, or.
I'm in the felony side. I could be over in about a half hour, if that's okay.
No, we won't be here for a half hour. We only have.
I'm sorry. I can advise you, Mr. Roque, these are technical changes. Judge Malika found proof evident or presumption great for attempted murder, first degree at his original first appearance. It just got booked as a murder because they couldn't book him for attempted murder. And the change of charge from firearm to a felon, it's a matter of subsection, but it's still a lateral change of charge.
Did you hear that, Mr. Roque?
Yeah, so are both of the charges lateral changes? Is what he said?
Yes, right.
Oh, okay, so then actually the judge I think Judge Malika originally did not find the proof as evident presumption of guilt is great. She didn't make a finding of that because it wasn't clear on the paperwork. So I don't know if there's any other paperwork that addresses that. But I do know that we do have we have a Arthur hearing set before Judge Weeks, I believe on May 15th was the first day we could get it. So I'd ask that you not make any findings about proof evident presumption of guilt is great based on the paperwork you have, and wait and let it go till the 15th when we have the Arthur hearing before Judge Weeks, if that's okay.
All right, we're just confirming that information.
Your Honor, unfortunately, for some reason, when I try to print out the page off Odyssey, it comes out blank, but I'm looking at it right now. Judge Malika wrote in probable cause for attempted murder in the first degree, then to the side of that wrote PG for count one, and ordered him to be
Say
held
that
no
again
bond.
there, I'm sorry. could you do that part?
They're saying on the paperwork, Judge Malika did write that she found proof evident presumption great.
I don't think so, but I could be mistaken, but my recollection, because I remember specifically asking her to not find that.
Well, they're
and
looking
when
at
I looked
the-
at the paperwork, when I looked at it, I believe, and I'm going by memory, I don't have it in front of me, that she did not make a finding as to proof of evident presumption of guilt, and she was going to wait till it went before the other judge.
That's
I
why.
specifically said that because of the way the warrant was for him to get picked up, because it was kind of conclusory, you know.
But that's why that's why we write on the documents, and we've looked at it, and it does say proof
And
evident presumption
I'm being
great.
advised by the jail, they have the same information.
Okay, so I'm gonna leave that, Mr. Roque, and since you have an author hearing
All right.
anyway,
Yeah.
that will take
That's
care
fine.
of it.
The bond was originally
Yeah,
set on
my
count
reading
two.
of it was, I thought she said not finding,
Okay.
but I don't know,
not
I don't have it.
binding.
If you have it in front of you, I'm gonna go with what you say if you can see it, because I don't have it in front of me now.
Okay.
Bond was set at 5,000 on count two. I'm just asking for the same
I
bond.
know count one, it was a no bond hold.
Yes, ma'am.
All right. All right,
Okay,
Mr.
so what is it? So count one's gonna be no bond, count two's
Right,
$5,000?
right,
Okay,
right.
cool.
All right.
Thank you so much. Thanks for calling me.
No problem. Mr.
Have a
Bernardine,
great day.
you too. Mr. Bernardine, your attorney does have an author hearing already set on the no bond hold, so I believe he said May? Was it what?
May 15th,
May 15th is the date for that hearing, okay?
before Judge Weeks. You
All
got
right,
it.
all right, thank you.
Thank you, Judge. Have a great weekend.
You,
I'll see ya.
you too. Okay, we have, Mr. Morel was left because we were waiting for,
I have,
did you give a copy to Mr. Reedy?
well, I thought he, when
Oh,
he declined.
oh, he's declined? Oh,
Obviously, if he does, I'll be more than happy to print Mr. Reedy a copy.
okay. It's 4.1. All right, Mr. Morel, you're before the court. Count one is trafficking in heroin. It's 4.1 grams, less than 14 grams, and count two is possession of cannabis, 20 grams or less. I do find probable cause. Mr. Morel, did you have an attorney? You gotta turn the mic on.
No, ma'am.
And you're proceeding this morning without an attorney, is that correct?
Yes, ma'am.
All right. So, state,
Your Honor, I would just ask the court to take into consideration when setting an appropriate bond. First, if convicted of this offense, he faces a 3-year minimum mandatory prison sentence. His criminal history, 2010 burglary causing damage to a structure or dwelling over $1,000. He was sentenced to 51.5 months state prison, released in September of 2015. Loading and prowling, 03. Delivery of cocaine, 98. Dealing with stolen property, 92. Those are his most significant priors, Judge. Nothing further.
all right. Mr. Morel, is there anything you wish to say in regards to setting your bond, sir?
Yes, ma'am. Right now, I don't think I deserve that high bond because I really didn't get caught with nothing on me.
All right, okay, don't say anything more. Your bond is $75,000. Good luck, sir. All right, so Brandon Woolery. All right, Mr. Woolery, you're before the court today for one count of premeditated murder. And I do find probable cause, and I'll hear from the parties further.
The state's asking for no bonds and a finding of proof evident, presumption great. Based on the affidavit, there was an eyewitness of the murder from Quanisha Hanna. Her statement corroborates evidence through the police investigation that the defendant was at the scene of the crime. Cell tower records also corroborate that he was at the scene where the murder took place. Relying upon the affidavit, we do ask this court find proof evident, presumption great.
Well, I'd point out the witnesses DNA and everything were found inside the deceased's vehicle. And she admitted that she traveled around in the deceased's vehicle for several days and never reported this incident. But that being said, my main concern at this point, if the court wants to find proof evident presumption, great, and hold Mr. Woolery without bond, he can deal with that issue in front of his division judge. So if you want to make that finding, Judge, we would object. But my main concern is invoking his Fifth Amendment right to remain silent.
All right. Ma'am, who are you? I'm sorry? Okay. Is there something that you wish to say? You don't have to say anything. You've been sitting here all morning, so I don't know if you wanted to say anything. Okay. All right. I do find probable cause based on the affidavits that has been presented to me. I am going to make a further preliminary finding of proof evident presumption great. That is without prejudice. Mr. Woolery will be held without bond, and he does have the right to have an author hearing before his division judge. Good luck, sir.
Your Honor, at this time, we would be invoking Mr. Woolery's Fifth Amendment right to remain silent, putting the state and all law enforcement officers on notice that they are not to make any attempt to contact Mr. Woolery or communicate with him in any way without first contacting his attorney. Mr. Woolery, I'm advising you not to discuss this case with anyone. Do not discuss it with anyone in the jail. You can expect to see them testifying against you at trial if you do. Do not discuss the case on the telephone. They are listening to your telephone conversations and they are recording them, and they will use those against you at trial as well. Do you understand, sir?
Yes, sir.
Okay.
Okay, thank you. I believe we are at the end of our docket.
Your Honor, before we go off the record,
Did we do this, Kelly?
on Mr. Casey, Mr. Reedy, you listening? On Mr. Casey, on checking in Odyssey, he's actually in JPTI and no longer on PTS supervision. So therefore, we're withdrawing our
Oh, yeah, we did.
revocation.
On Casey?
Yes.
I don't even remember.
That's the one with that you did the no bond hold.
Okay,
Yeah. He's actually in JPTI with Judge Merrigan, no longer on pretrial supervision, so we're withdrawing.
okay.
We don't have any paperwork.
So,
Just scratch it out. I did paperwork.